Hi, everyone. Welcome to Pop Crime TV's The Outlier podcast. I'm your host, Lauren Conlin. I am clearly not alone right now. I am joined by criminal defense attorney, personal injury attorney, Matt Tympanick of Tympanick Law in Florida. And we are going to be discussing the ongoing murder trial of Karen Reed amid there seems to be something going on every single month, every single week, I want to say, pertaining to this case and the death of Officer John O'Keefe. And I, for one, try to stay out of all the drama. There's a lot of drama surrounding this case, but just to get this out of the way, Matt and I, we don't necessarily see eye to eye on this case. But for me, I don't think it's fun to just sit there and talk to someone who has the same opinion as you. I think that we can disagree. Respectfully, and we can have a conversation, which I believe is something that this case has been lacking. It's just crazy that this seems to have gone in this direction where you can't even discuss things civilly. But Matt, I haven't done an update on this in a while, but of course we know that back in July, the Karen Reed, it ended in a mistrial. So the jury was hung on whether or not she intentionally killed John O'Keefe, whether or not she left the scene, or whether she accidentally killed him, whether or not it was manslaughter. And jurors allegedly came forward to the Commonwealth and to the defense, citing that possibly they were only hung on one charge, which was manslaughter. And then we saw that her team argued to the Supreme Court that the two charges should be dropped, the second-degree murder charge and the leaving the scene. There has not been an answer to that as of yet. And then we also recently saw in a discovery hearing that the Commonwealth was seeking the cell phone records of Bill and Janet Reed, Karen Reed's parents, specifically the night that John O'Keefe was killed, and then dating back 30 days because they wanted to compare the fact that they believed that she called her parents at 1:30 a.m. that night. And then we saw that the Commonwealth wants just journalist records from Dateline 2020 and Boston Magazine. And then we saw some other things from David Yannetti at the end where it got a little spicy. And he talked about the DA and how he does not trust this DA. So a couple things right off the bat. Judge Cannoni ruled that the cell phone records of the Reeds, that wouldn't happen. The defense said it was a fishing expedition, and Cannoni said, there's not really enough here for me to permit this. So what do you think of that ruling right off the bat?
I think that the judge made the decision based on what was presented in front of her. It definitely felt at times that it was kind of like, all right, let's see when we can get these kind of records. To get these kind of phone records, you have to have a specific and articulable purpose. It's like, all right, you have a reasonable belief that these messages contain include these type of conversations that would lead to admissible evidence. That's kind of the standard to be able to get these kind of records. But based on what they presented, it didn't seem to overcome any kind of right of privacy that Bill and Janet Reed actually have in this type of case. So I think I understand the ruling. I think definitely the notes from the Dateline interview and the Boston Magazine are definitely going to be more interesting because that would be notes that were made because, remember, anything Karen Reed says at any time is admissible as a hearsay exception because they are admissions. The defendant's statements are all admissible in a criminal case. So if she says, oh, I backed up into him to the Boston Magazine, not saying that happened, that would be admissible if the Boston Magazine person who she made that statement to took the stand and admitted that in court. Otherwise, it's hearsay, not within an exception. So talk about like the phone records. How they would have came in if they were admissible is that they would have needed Bill Reed to testify in court that his daughter sent him messages or made a phone call on the night in question. to authenticate the records. Otherwise, they would not come in as they'd come in as the hearsay, not with an exception. An argument could be made that they could come in under a business records exception, but that's how they would have came in using Bill Reed.
Yeah, and I guess, they spoke, the defense spoke and kind of said, look, you have Karen Reed's cell phone records. You've had these forever. And I guess I'm wondering, as a lay, why was this alleged call to her parents not brought up in the first trial? And again, I mean, and we can get into this a bit, but I mean, did they use a different service all of a sudden? It's confusing to me. I don't understand where this came from. And I know it's a new trial, right? I get that. But
what I can tell you is this. From the first trial, ADA Lally did whatever you believe, whatever people have their opinions about how he did. He did an admirable job. But that's not to say I didn't have significant critiques when I was on Law and Crime, Court TV, about how he presented the case. One of the things that would have been is like, if you have this phone call, that would have been something that should have been brought up at the first trial. It's like, did she call her parents? Do you have proof of this? Because you know what her phone number is. And if you did any kind of investigation, you would know what his phone number is. And you would have called that and be like, yes, she called me and she said this on the night in question. Additionally, I think one of the biggest things, the biggest themes for the second trial is going to be a much more heavier focus on the accident reconstructionist. As we saw in the first trial, the Commonwealth did not really, what's the best word I'm looking for? Elaborate on the construction. Like they put like all the pieces together, but they weren't able to elaborate. They weren't able to explain it. They weren't able to make it in a way that made sense to a jury, especially the alleged backwards acceleration. Like I heard that and it didn't make any sense to me. And I'm like, if it's not making sense to me, it's certainly not making sense to people who haven't done over 40 criminal trials.
Exactly. I mean, that was one of the biggest things for me. And, I said this at the beginning, assuming that everybody knows, everybody's on Twitter and everybody's watching everything that has to do with this case. And that's not necessarily true. But, for me, I never felt like the Commonwealth proved their case beyond a reasonable doubt. And this is a huge part of it. And I know you believe that the simplest, most logical answer would be that she backed into him and she killed him, Officer John O'Keefe. I mean, and I have a lot of trouble with this for a lot of reasons. I mean, you talk about the accident reconstructionist, Trooper Paul, and, there was a guy, I believe just on Twitter, and this was actually brought forth in a recent motion by the Commonwealth where he offered this new scenario here based on the key cycle starting at a specific point, at how that if it started at this point, then it would have made sense that she could have hit him. But according to one of the witnesses, I believe it was Ryan Nagel, she never turned her car off. So this is all really confusing at this point, because it's like, how are you going to get this accuracy here if a witness stated she never turned her car off? And additionally, the investigation was done by somebody that wasn't necessarily or who didn't necessarily have the credentials to do this, and it was so incredibly poor. How is that going to look in the second trial if all of a sudden they have to say, well, wait a minute, wait a second, our team didn't do the best job the first time around? Well, it's like you don't really get do-overs here in death investigations. But please correct me if I'm wrong. How does this look?
So what I can tell you is this case, how it was presented in the first trial, was definitely flawed. And the way it was very simple is how it could have been presented. First and foremost, there were pieces allegedly that were presented at trial of the taillight on John O'Keefe's clothing. Where it was on his clothing, that wasn't really flushed out as much as the word. Are they inside the fabric? Is it on the fabric? Could it have been placed there? All of that needed to eliminate any kind of situation where they can talk about this. We'll get to, of course, the conspiracy. But For one thing, the pieces of the taillight are on John O'Keefe's clothing. John O'Keefe's DNA is on the bumper of the vehicle, and it's like, okay, how did those two things happen? It's like, did somebody plan it? Probably not. But did you explain it to the point that anybody could understand it? No, absolutely not. And that's the biggest problem with it. For me, when I see all of that, including putting it all together, the pieces of the taillight were found at 34 Fairview. It wasn't found at John O'Keefe's residence. That's also important, and that's also what should have been kind of really, really hammered home. They mentioned it, yes, but it's like when you search the scene at John O'Keefe's residence, were those taillights there? No. Piece of the taillight? No. Would you have photographed if it were? Answer, yes. Because that, for me, that's where the biggest part of the case is they're talking about, oh, this is where she cracked the taillight. Yes and no. What you also have to see is they talked about look the other way. Well, that also works both ways. When you look at the video, everybody's looking up, backing up into the taillight. What they should have also been watching is looking at the individual inside of it to what they're actually doing. There have been claims, and what I want to know in the second trial, because, like I said, it starts over all again. Karen Read is presumed innocent until proven guilty, and she is not guilty until the evidence overcomes that burden. But when you look inside the vehicle, is there some kind of software that would prevent? It's a newer Lexus. Does it have a rear light camera, so you can see if you're backing up into a vehicle? And if it is, are there motion warnings that tell you you're about to back into it? Was that overridden? That should have been introduced, because you need to eliminate each and every one of these kind of situations to be able to prove. I've proven criminal cases and I've defended them, so I know how to talk both sides of it and know how to get through to a jury of what they want to know. This is a highly contentious case, and nobody on the jury is going to be able to convict and be able to 12 people all agree unless they leave no doubt. The burden is beyond a reasonable doubt, but unfortunately for the Commonwealth in this retrial, no juror is going to want to be able to go home back into their community in Canton or wherever in the Norfolk County and be like, yeah, I convicted Karen Read, and they get ripped apart by their family members who may or may not disagree with that.
Okay, well, two things here. For whatever reason, when you move your arms, there's this crazy static sound. I don't know what's going on, but maybe you're hitting something on your computer, but I just didn't want to distract people from what you're saying. But I think that, the taillight, and it's like, we could get into this, but it's like, it's been debated, it's been done. I feel like they put the doubt in my mind because it wasn't discovered really until hours later when there was even more snow on the ground. So that's where my head goes. But going back to, I guess, Hank Brennan and his reasoning behind wanting these calls at 1:30 that were allegedly made from Karen to her parents, he stated that he believes that she made these calls after she hit him, indicating that she knew that she hit John. Maybe she thought that she killed him, but he said, John could have been saved. He could have been saved if she just did something here. And I just have and I've always had a hard time with this. I feel such a hard time with this. And that was not mainly, I shouldn't say that, but it was partially due to the fact that she did call him so many times, screaming, and the text messages calling him an effing pervert, making up and I'm not going to say like the girl lie, but we can do things and say things, I guess, for it to get someone's attention, a male's attention, which I believe that's why she was like, I'm here with your effing kids, all this stuff. I don't really believe that this was a murder, I guess. I really don't. I would say, because of all these things at best, and if you can prove this to me or the Commonwealth can prove it to me, fine. But at best, it's like she accidentally hit him. She didn't know. She took off. But they have completely turned this into, in my opinion, something that it's not. And that's based on the circus that has been created. That's what I think. I just think that you've got this prosecutor who defended Whitey Bulger, which, it's Whitey Bulger's right to have a defense attorney, and Hank Brennan was great at that. But now he's here trying to paint Karen Read into this vicious, cold-blooded, dangerous, sociopathic murderer. And I just don't think that's necessary. And I don't think that's the case. And I think that the entire Commonwealth has just lost sight of what's really going on here. And they can say, Matt, oh, it's because a police officer died, but that's not why they're doing this. I'm sorry to say, that is not why.
What I would say, Lauren, is this case should have been much easily been prosecuted. But remember, what happened eventually is that individual content creators who will remain nameless for purposes of this created this conspiracy. And it took this case from what would have been probably, in my estimation, and I'll tell you some inside information in a bit. It turned it from a manslaughter case into a murder case. To this point, somebody close to, I'm not going to say which side because it doesn't, I don't want it to affect any kind of my critiques of this case, sent me the indictment in, I think, June 2022. So this is long before anybody knew anything. And I reviewed the indictment and the facts of the case when it was first presented. And I said to this individual when they sent it to me, I said, very simply, if they can prove this, I think this is a manslaughter case, a DUI manslaughter case. And then later it turned into a murder case, I believe. And I never really understood. I understood the facts that could get an indictment, but I never really truly agreed with a murder case. My belief on this, and remember, it starts over the moment the new jury is begun. But we're talking about evidence from the first trial. My always belief is that the defendant was highly intoxicated on the night in question. I think that's to kind of argue that, which I believe David Yannetti and Alan Jackson kind of did in the first trial. That's not where you die on that hill. Karen Read was highly intoxicated on the night in question. I think that John O'Keefe got into a fight in the vehicle. I think John O'Keefe got out of the vehicle. I think he walked behind the car, and the defendant was not paying attention, didn't know he was there, and backed up to leave and hit him by accident. I don't even know if she even knew she hit John O'Keefe. I personally think that based on everything that I've read, the evidence presented, I think it was just an accident. That being said, it's okay. Why is the Commonwealth kind of doing a different approach? It's because the defense has elevated this case from where it is to this assault on the district attorney, trying to destroy the credibility of the district attorney bringing this case. So it's like, they kind of stayed above the fray in the first trial and allowed the defense to do that. And they kind of and here's the reality. They kind of lost the PR battle in that regard. The defense was firing everything they could from the courthouse steps. The defendant herself has her own publicist and social media company that kind of does everything for her online. Very interesting stuff. So I definitely think the prosecution is like, all right, we don't want to do this, but it's time we start to get into this game. And we should be above it. That's the way it should work. The prosecutors are held to different standards than defense attorneys. Is that right? No. But ethically speaking, they are. But I think that by bringing somebody from the outside and getting a special assistant DA and one who was a high-profile criminal defense attorney, it's like, we're having somebody who has no connection to this office whatsoever. We brought in somebody completely independent and somebody who can go toe-to-toe with Alan Jackson and David Yannetti.
Right.
So I think that was the thinking with Hank Brennan.
Yeah. So just going back to the defense and I guess the conspiracy, I do want to go over something with you, Matt, and because you are a criminal defense attorney, going to share this. So this is where the alleged conspiracy began. And I want to point this out because there's been a lot of different theories sparked online and a lot of points of contention here based on what this private investigator had initially stated. So what this states is that this is from Brian. This is to Brian Tully from Sergeant Yuri Buchanan. So he basically states that they were able to interview Stephen Scanlon on October 16th, 2023, about how everything came about, what he had said to Karen Reed and what he had initially said to David Yannetti. And this is again how it relates to the death of Officer John O'Keefe. So Stephen stated he initially reached out to Karen Reed over Facebook Messenger, said he was a private investigator and would be willing to put another set of eyes on the investigation, saying he would do it free of charge. Karen says, talk to my attorney, David Yannetti. And then Stephen says he's not sure of the exact date, but he called Yannetti's office and offered the same services, suggesting that O'Keefe might have been beaten up and that he was not sure what happened, but would be willing to work on the case, obviously only if agreed on by Yannetti and his client, Karen Reed. Following their phone conversation, David Yannetti asked Stephen to come into his office to further discuss the matter, which Stephen did back in early 2022. And just to shed some light on this, it turns out Stephen Scanlon knew Brian Albert, who was the homeowner of 34 Fairview at the time. They boxed together and they had just known each other for a very long time. Now, Stephen said when he went to visit Yannetti, there's another individual there named Paul Mikowski, who's another PI. And during the meeting, Stephen was asked if he knew Colin Albert and an ATF agent, both of whom were allegedly in the home during the evening hours when O'Keefe was killed. According to Stephen, this was the first time that he had heard of Colin Albert and an ATF agent being possibly involved in the matter. And both had been mentioned by Mikowski and Yannetti. Again, Mikowski is the other private investigator in the office. And then prior to the meeting concluding, Stephen stated that Yannetti handed him a check for $1,500 to keep his eyes and ears open in the Canton area in regards to the O'Keefe case. Stephen took the check, but he consulted with his attorney and then returned it to Yannetti since he's not working on the case. And then he further felt it would be a conflict of interest. And just lastly, really quick, it says in the days and weeks following the meeting, Stephen was in communication with an individual named Jack Hollow. Jack Hollow, according to Stephen, is a mutual friend of both Stephen and Mikowski and used to work with Brian Albert. Hollow shared information which he had learned from Mikowski. That information being that Yannetti and his team were looking into Colin Albert and the ATF agent since Colin allegedly had beef with O'Keefe. I asked Stephen how come he didn't reach out to investigators when he learned this information, to which he stated that he had learned everything he had learned was fourth, fifth, or even sixth person removed from the source. Thus, he didn't think it was important or credible to contact them at that time. He circled back on about an event that he had mentioned earlier in the conversation. He said that he was at Patty's Irish House in Newton, Mass for lunch one of the days following the homicide taking place, and the local news is broadcasting coverage on the case. He sparked up a conversation on the matter with the bartender, who told him that she lives in the neighborhood where O'Keefe was found, and that days following the investigation, she received a call from an unknown party telling her that the police were looking for ring cam footage and not to release it to authorities. He didn't know the bartender, blah, blah, blah. Okay. So really quick, I just want to point out something about this. You are a defense attorney. Stephen Scanlon, where he may not have mentioned names, right? He didn't say Colin Albert. He didn't say Brian Higgins. He said he may have been beaten up and he has history with Brian Albert. As a defense attorney, if you hear this and your client is facing serious jail time and, you know, there's doubts here, what do you do with that information that he says? Do you dig into it further with other people, other locals? I mean, or do you do nothing? And to be clear, I am not perpetuating a conspiracy theory. I am not pointing fingers at anyone. I just want to understand, I guess, why, people are I guess coming down so hard on defense attorneys who are doing their jobs. And again, I'm not saying that this is necessarily right. I don't know anything about Colin Albert. I know nothing about him. I feel like that is your job to dig further if you are told this theory by somebody who has a history with some of these locals involved. What are they supposed to do? Just sit there and go, "Oh, okay, thanks."
So one of the what you as a criminal defense attorney will do, you have to investigate it. So here's what I think was in the end of Scanlon's the back and forth, because I think it was in the Dateline piece. One of the things was it's like, okay, investigate it, and where does the thread lead? And the individual who brought this conspiracy to you eventually disavows it. Stephen Scanlon. The reason why he was never called as a witness at trial by David Yannetti is because eventually he
Right.
basically ghosts Yannetti, and he later says, like, well, that's not really what I said, and I don't know if I believe this anymore. So you can look at it from one of two ways. Either A, you could say that, oh, he got scared, somebody got to him and somebody scared him off, and now he's kind of throwing cold water on his own idea. Or you could the idea that it never really existed in the first place. So your job as a criminal defense attorney to investigate and to make claims that you believe you have a good faith basis to believe are true. They don't have to be correct, but they have to be in good faith. You can't just throw everything against the wall and see what sticks. And definitely what happened in this case is, and believe me, I understand it's a very high profile case. It's a case where probably the biggest case Alan Jackson's handled since Harvey Weinstein, which he represented, which I think it was his L.A. case or his New York case where he was convicted. And you have a billion eyeballs, you have millions of eyeballs on this case. Do I get it? Yes. But do I agree with how it's kind of, instead of, all right, let's put this conspiracy front and center, and more putting it online. And that's kind of where it originated. And we know it's not fiction. It's not really, oh, we don't know this. There are direct communications with Karen Read and bloggers, very famous ones, who perpetuated this conspiracy that have been kind of debunked. And to get back to what you were saying, you absolutely investigate it. But if you do not believe the evidence, what you were presented is true, you cannot go forward on it from an ethical standpoint. And that's kind of what we saw at the trial, is they kind of poked holes in it, but didn't go so far as to basically get into, it's like, all right, this conspiracy. Because the biggest thing was it just got too big. It wasn't 2 or 3 people. 2 or 3 people could have eventually believed that it's like, all right, couple like Brian Albert, Colin Albert, a couple other people, Brian Higgins came together and to cover this up. Maybe. I'm not saying it's true, but they maybe could have believed that. But unfortunately, it just became so big that everybody's involved in it. Trooper Michael Proctor's involved in it. The EMT who heard Karen Read say, I hit him. And it's just like 20 other people that I could go down the list one by one. And it just became too big. And it's like, you can't get 10 people to agree on how something happened, much less 40. So I definitely think that
I agree. No, Matt, I agree. Continue.
And definitely what with this case is this conspiracy lives more online, because what I've seen with individuals, and that's why I give my hats off to you, because, and and I have turned down other appearances on adversarial prop podcasts, because it's the idea that, all right, is this just going to be a situation where it's, are we just going to talk the facts, talk what we believe our opinions? No, let's talk facts about the case. Let's talk about what was actually presented at trial, not things that were concocted online. And definitely with what Jackson and Yannetti did was, yeah, they definitely empowered, indirectly or directly, content creators and bloggers online to perpetuate this conspiracy. And it worked because it made the case much more high profile. Because I remember back in January 2024, I texted a producer at Law and Crime and I said, hey, this case, this Karen Reed case, is blowing up online. It's getting unbelievable traffic. So when it happens in April, be prepared for a gavel to gavel, day in and day out press. Because I told them, quote, I hadn't seen anything like it since the Johnny Depp Amber Heard trial. Nothing.
Right.
It is literally the criminal equivalent of that case of how content creators and attorneys with agendas have kind of picked up on it. So I definitely think that I would have done things definitely a little differently. But do I understand it? Yes. Do I agree with it? No.
Yes. And I think that, so content creators aside, all of that aside, I guess my point here is that they hear this and they take it a step further, right? Because it's their job here to look into this. As they take it a step further, they see all of these quote unquote coincidences. Me personally, Matt, I don't believe in coincidences. And so again, content creators aside, any type of harassment aside, which is terrible. I don't agree with that at all, clearly, because nothing's been proven in the court of law. But you have here the butt dials, right? You've got the doubt of the dog, if you want to include that. You've got the doubt of the sale of the house. And again, I'm not saying anything proves that people murder John. I'm just saying that as they're digging, they discover this. They discover the Google search, which, they believe happened at 2:27 a.m. And by the way, Matt, at this point, I don't even think it matters about the Google search, because the police investigation was so shitty, in my opinion, and there were so many missteps there. So I guess my whole thing about this is, I wish that things had unfolded differently. I do. But and yes, things have gotten completely out of control. I guess would you say socially? Because there are reports of the family of John O'Keefe being harassed, which, my God, is horrible. I mean, regardless of what they think, their son has been killed, and additionally they lost a daughter previously. So all of that is unacceptable. But just bringing things back together here, I just think that everything is just wrong. I just don't think this should be this huge murder trial with the Commonwealth spending all this money and trying to make her this murderer. I do feel like this is all a domino effect of the chaos that this case has caused, and unfortunately, it's just so terrible for Officer O'Keefe.
Yeah, and definitely what you were saying, kind of bringing back about the Google searches. The biggest thing was that with the tabs, that's another thing at the retrial the Commonwealth has to do a better job of. They need experts, and not ones that you need ones that be like, those Google searches did not occur at 2:27. Tabs were opened at 2:27 a.m. And they need to explain that. They need to eliminate each and every doubt. I think 88 Lally did a pretty decent job, but at the same time, it left the door open for people to be able to argue the 2:27. Like, maybe it did happen at 2:27. If it did that, why would Jennifer McCabe be searching that at 2:27 a.m.? That's the key. In these types of situations, it's beyond a reasonable doubt. But unfortunately, since this case has gotten so big, you got to eliminate each and every one of these. You got to have an expert for this. You got to have an ironclad expert for the accident reconstructionist, one who can be able to effectuate it. And it's a situation, everything you just listed. Okay, why did they sell the dog? Why did they sell the house? They need to be able to explain that all at the next trial. It will make it, and it'll be open for cross, because once you open the door on direct, it makes it available for cross. But the jury needs to hear all this. You need to eliminate these doubts, because I think whatever I saw for the reports, the final verdict, the final count on the verdict was 9 guilty, 3 not guilty on the manslaughter charge, with Karen Reed acquitting on murder and the leaving the scene. I did a mock verdict in the case right before the trial, right before the verdict came down, because I was like, I listened to all the evidence and I did it based on the verdict. I actually acquitted Karen Reed on the murder charge because
Yeah.
the evidence presented did not support a conviction for murder. And that's how the standard is. It's not a, because one of the biggest things I've seen is like people like, you're a defense attorney. How can you not be on her side? It's like, well, no, I'm on the side of justice. And
Yeah.
that there are plenty of other attorneys out there who are going to tell you exactly what you want to hear. I'm going to tell you what, based on my experiences as a prosecutor and a criminal defense attorney, what this evidence presented means, how they are going to use it, how it's going to be interpreted, how to attack it, how to rehabilitate it. That's what my job is, and that's what I'm going to do. It's never going to be pandering, and definitely for the retrial, it's going to be the same thing. And like I said, the case starts over again, and it's right now as the jury walks in, she's not guilty, no matter what,
Right.
and that doesn't change until the burden is met. And I definitely think that is so important, and that is our system. Cases are tried in courtrooms. They are not tried online. They are not tried on the footsteps of the courthouse, in the
Right.
media. They are tried in courtrooms with 12 members of the community.
Yes, and last thing I'll say, Matt, because I know you have to run, but just really quickly, I also believe that there may not be some big conspiracy here, and that's not necessarily in my opinion what was needed to prove her innocence. It was more the investigation and how horrible it was, and also the fact that these statements were conflicting. You don't want to say that you heard Karen Reed say that she hit him to the grand jury. You don't want to say that in an initial police report when you're being interviewed by the police. None of that ever made sense to me. And they're going to, again, have to do a much better job in come April. Because again, the trial has been pushed back once again to April of 2025. But
I don't
Matt,
think it had.
what's
I
that?
was going to say it has. The case hasn't officially been pushed back yet. They requested it, and Judge Canoni
Oh, it
hasn't granted
hasn't.
it yet.
Oh, I thought it
No,
was a done deal. Okay.
no, it was not. So what you are saying is the correct defense. So all throughout the case, and I posted, I don't know how many times on Twitter. I will never call it X. It's Twitter.
I know.
And without this case, as I said, the investigation and reasonable doubt is still the best defense. And it's because it's like, if you are able to make a reasonable argument why the evidence shouldn't be trusted, that is how you get potential reasonable doubt. All this other stuff did nothing. All it did was just create the publicity of it. But saying, why are you using red Solo cups to get evidence? Why are you doing this evidence and you have individuals who have conflicts of interest? Trooper Michael Proctor, on the day in question, knew he had a potential conflict of interest and should have immediately been like, somebody else needs to come here. That is where the defense should have focused on. That was always the best defense. But guess what? That doesn't get media attention that it would. But for Alan Jackson to take this case, there had to be substantial media attention, and this conspiracy and everything that's been created online, that is what got more eyeballs than a regular homicide of a Boston police officer, alleged homicide.
Yeah, well, I guess we will wait and see what comes about in the second trial. And oh my gosh, how stressful for everybody involved. The O'Keefe family, my heart goes out to them. I just, I can't imagine going through all of that again. And even, Karen Reed, I do at this point. I don't think that she hit him. I really don't. And again, I am open to sitting there and having somebody prove it to me. But first time around, I didn't feel like it was proved beyond a reasonable doubt. And that is on the Commonwealth, and that is their job. And the defense doesn't have to really prove anything. They just have to rebut it, right? So Matt, where can people find you if they would love to follow you?
You can find me on all social medias at Tympanick Law, Facebook, Twitter, Instagram, LinkedIn, and upcoming in January 2025, my new YouTube channel at Tympanick Law.
Oh, that'll be so exciting. Okay, I'm ready for that. I love the LawTube channels. They're awesome. And I love the fact that you are just no bullshit, no fluff, and you're what's the word? You're unbiased. Is it not biased? Unbiased? Yes, unbiased. But anyway, thank you so much again for joining me. It is always a pleasure. Have a great rest of your day.
Thank you, Lauren.